Friends, good morning. I'm B.S. Satyarthi from Global College of Law. In the series, yesterday we had taken up one paper, that is IPC1860. Today also we shall continue with that. And I want to tell you very clearly that here IPC, the background of IPC, what we had seen. I hope everybody has got it very clearly. IPC was framed consequent to Law Commission of India 1834, headed by Lord Macaulay, and it was drafted in 1860 and enacted in 1862. This is a substantive law. Substantive law where rights, duties, responsibilities all are defined, and also the punishment if somebody does wrong. Now, second part of the same, and which is very important, is what are the general principles of crime we shall take up. First of all, let us know what is the definition of crime. And definition of crime very precisely given is by Blackstone. Blackstone has worked a lot on crime, and accordingly he has defined the crime. A crime is a violation of a right. A crime is a violation of right, considered in reference to the evil tendency of such violation as regards the community at large. And this violation may be of individual or of society. This is not necessary that only of society. If any right is violated, it will be crime, even if of an individual. Suppose any theft has taken place, so here point of society does not come but that of individual, so it is also a crime. Crime in earlier days was of single type, that was the consequent act. There was no tort, but later it was divided in two parts, crime and tort. In primitive stage, crime was dealt in a different way without considering human touch. But later on, when bodily punishment came in vogue, it was made a change. It was made with a change that crime not necessarily is the intention, but sometimes it happens even without intention. And what is the act which is crime? Which is the act which is not as per law of the state, or which state wants to control, is called crime. State's responsibility to detect, control and punish crime. Circumstances when morality amounts to crime. Crime and morality distinction. Distinction between crime and other wrongs under common law. What is common law? Common law is the law made for colonies which were enslaved to British rule. Common law was made by the British government for British India and other colonies. This is other than the criminal law. So, tort as on date is part of common law. Tort is one subject paper for LLB, and I am sure the study of the same is going on. In case anybody finds any problem in tort, can also discuss. See the characteristics of crime. What is crime? See, outcome of any act is harm. If any harm has taken place, then it's a crime. And it should have been through human conduct. See, any harm happened to anybody, individual or society, through the conduct of any human being, it is a crime. And what is the act? The act which is required to be prevented by the sovereign. There are certain acts which are not required to be prevented, then it is not a crime. Sovereign state desires to prevent, then it is a crime. Measures for prevention include threat of punishment. The measures taken by the state to prevent the crime is threat of punishment. Punishment may be given in either of the ways. There are certain ways taught for controlling crime. Special proceedings employed to decide whether the accused has caused the harm and inflicting punishment. See, there are special proceedings employed by the state have to decide through that accused has caused the harm and inflicting punishment. So this is the crime. Place of criminal law and criminal science. Three branches of criminal science are there. Number one, criminology. It deals with the causes of crime, both biological and social. Criminal policy studies the measures to limit the harmful conduct, takes measures by setting up social organizations to prevent harmful activities, and lays down the principle by which harms are classed as crimes and how criminals are to be treated. Criminal law is the law considered as taught what is crime, that prescribes the punishment. It is an instrument used to implement the criminal policy. जो क्रिमिनल पॉलिसी गवर्नमेंट की है उसको इम्प्लीमेंट करने के लिए जो रूल्स एंड रेगुलेशन बने, दैट इज कॉल्ड क्रिमिनल लॉ. Criminal liability, you know, when there is a crime, of course there is a criminal liability, and criminal liability will be dependent on certain factors. Dependent on certain factors. See, very clearly we should understand that whether the crime has happened with the intention or without intention. In earlier days there was no distinction between two. It was treated only consequent to the harm inflicted. There was no way to see this with the intention or otherwise. But at a later stage, when the bodily punishment came in the vogue, it was the result that thought was given to the crime. Crime is done with ill will or not. Any crime done with the ill will is different. Otherwise, there is a strict liability clause. Strict liability clause means when there is no intention and it is found that there is no intention of anyone. So strict liability means what the consequence is there for that particular harm, there should be a fine and maximum imprisonment of 1 year. This is strict liability only when there is no mens rea. Ill mind is absent. Strict liability crimes are those crimes in which defendant is held liable for a criminal offence he committed even if mens rea is absent. Though the defendant did not intend any harm by his actions and was completely unaware of that he was committing an illegal act. उसको ये भी पता नहीं था कि क्राइम जो कमिट कर रहा है वो क्राइम है या नहीं. The doctrine of strict liability speaks about fine plus imprisonment depending on the nature and extent. Most cases of strict liability are minor infractions and misdemeanors. Felony and misdemeanor. Misdemeanor means small offenses. Felony means big, huge type of the crimes like murder, rape, and all comes under felony. Misdemeanor means small crimes, small this thing, not nearly as serious as felonies, but still warranting heavy fines and up to a year in jail. Examples of the minor offences for which violators are held strictly liable are parking violations, speeding knowingly, selling alcohol to minors, in some jurisdictions employing people under the age of the 14. These are the misdemeanors. Wrong जगह पर पार्क कर देना और स्पीड से गाड़ी चलाना बच्चों को अल्कोहल बेचना, ऐसे ये छोटे छोटे जो क्राइम है, ऑफेंसेस हैं, दैट कम्स अंडर misdemeanor. And felony, I told you, a big type of the crimes like loot, like rape, like murder. So these are the things. Mental element, suppose any mental intention is there to constitute crime, subject the offender is to a liability or punishment. To produce legal criminal guilty, a mental as well as a physical element is necessary. Thus, to use a maxim actis non facet reum mens rea, the act does not make a person guilty unless the mind is also guilty. So this is to be understood well. And without that, there is no this thing. If intention is wrong, intention, without intention we cannot do anything. Intention to be seen first. Actus non facet reum mens rea. The act does not make a person guilty unless the mind is also guilty. It is a well-known principle of natural justice, meaning no person could be punished in a proceeding of criminal nature unless it is known that he had a guilt mind. See, actus, again I say, any act done without ill will not count to be crime. And any act which is lawfully prevented and does somebody, then he is liable. Such results of human conduct as the law seek to prevent. For example, a repeated stabbing B thereby cause serious injury to his heart and lungs. Because of this injury, B dies. A stabbed B with an intention to cause death of B. Here's A's act of repeated stabbing and injuring B's conduct. The result of such conduct is the death of B. Mere injury caused by conduct, not actus reus. Injury caused by conduct is not actus reus. Actus reus means when it is prevented, it is prohibited by the act. For example, when a court sentences death penalty to a person and the execution takes place. Here जो जल्लाद ने फांसी लगाई है वो उसमें नहीं आती है. This is not actus reus. This is not crime. See, we have to understand that certain law cases are there. R versus Lave, R versus Jordan, R versus Horsey. These are to be seen for seeing the mens rea and many more. Contributory negligence, when anything is happening through a people more than one and it results into negligence, so people are liable for contributory negligence. Even person driving horse cart on a public road, encouraging each other to drive it at dangerous place, killed a pedestrian. It was alleged that deceased is deaf, careless and negligent. So that person is also to extent of this thing, to that extent is liable. The person, contributory negligence, he becomes the part of contributory negligence. Anybody liable for contributory negligence is also liable. As we have been talking very frequently, mens rea. You know, criminal law is subject to mens rea. Crime is subject to mens rea, means ill will. But we have to very well understand, one of the main characters of our legal system is that individual's liability to punishment for crimes depend upon other things, on certain mental conditions. So mens rea should be there. With ill will, ill mind. Development of mens rea, you know, earlier time, English criminal law began with the strict liability clause. Earlier it was not there. Earlier only the consequent act harm was counted, and based on that only punishment was awarded. So mens rea to be understood. And when we talk of mens rea, there are certain examples that actus non facit reum nisi mens sit rea, means act alone does not make a man guilty unless the intention were so. Intention should be also there. This is the mens rea. Compulsion, any act is done under compulsion cannot come under mens rea. See, somebody did not know and some wrong happens due to his negligence. See, yesterday I was reading one judgment of the court. One boy has borrowed bag from his landlord to go for interview, to keep his papers, go interview. But in bag there were live cartridges, ammunition. And he was caught by police. And all the courts had given punishment, but in High Court Delhi, final judgment came because he was not aware of this thing, so he is not liable. It's a very good judgment, but only thing is that here true reality to be known well. See, these things are there for mens rea. Indian Penal Code, when we talk Indian Penal Code, there is no word mens rea at all in any place. Only definitions are complete in itself. Accused might have done, and that states about the state of mind with regard to that act when the was doing. See, in IPC there is no word mens rea. However, equivalent words to those of mens rea in the IPC used are like dishonesty, section 24, fraudulently, section 25, reason to believe, section 26, voluntarily, section 39, likewise. And for that certain case laws are there. Sankaran Sukumaran versus Krishnan Saraswati, very good case is there. Virudu versus State of Andhra, very good case is there. In conclusion, we can very well say that in modern statutory offences, the maxim has no longer applicable, and the statutes are to be regarded as themselves prescribing the mental element which is pre-required to a conviction. So mens rea is an essential element of crime in every penal statute unless the same either expressly or by necessary implication is ruled out by the statute. So we have to understand that any crime without mens rea is not a crime, but crime is always with the mens rea intention. So this is to be understood. Friends, this is the second lecture, and I want to conclude. Please, if you like this lecture, please subscribe and also advise your friends, request your friends to subscribe to understand IPC very well. We will be completing IPC in 20 lectures, 2 lectures are over, and I am sure that in coming days you will give a proper attention and also listen it in proper lines. So thank you very much, thank you very much, thank you so much.